Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 295 of Registry Matters. Good evening, fine sir. How are you?
Doing awesome. I am really glad that you had me back one more time.
So again, I have this cadre of people, and I just start going down the list, and there's Leah, and there's Rocky, and then there's all these people that I try, and I say, hey, do you want to be on the show? And they all say no, and on the last line, it says Larry. So I had to call you again. It's very sad.
It is indeed for the audience, because I can do my best to alienate a couple tonight, I'm sure.
Yes, I'm sure. And that's without even trying. You're trying to actually play it down to not offend them, and they'll still be offended. Just think if you turned it up a notch.
So I do pretty well already.
Well, you know the drill. Make sure that you press like and subscribe. Remember to show your support by hitting those buttons or leave a 5-star rating in your favorite podcast app. It really makes a difference for us. We truly appreciate your love, and in return, we're here to keep delivering content you'll enjoy or be offended by. If you're feeling generous, Patreon support would also be incredibly valued. Thank you for being a part of our community. And somebody started echoing back. Who was that?
It was me,
all right,
accidentally.
Anyway. Why are you messing up the intro, Larry?
I was getting paid big bucks to do it. I was bribed by a competing podcast.
I could see that, actually. All right, but then, so download the show as a podcast and listen on your favorite podcast app. Larry, it's your time. What is our agenda for this evening?
Well, mostly we're going to be doing legislative advocacy. That bill from Oklahoma that we talked about last week, there were two of them, and one was quite lengthy. And we're going to get into that, and possibly going over to West Virginia. Not much has happened there. And then any backfilling we need to do on our New Mexico session. And also we have some articles if time permits. And then you got a phone call or voicemail. Anyway, you got from somebody who had some issues. What was that name? Eric, right?
Yeah, Eric.
Yeah, that was quite a message. So we're going to dig into that and find out if it could help other registrants who might encounter something along those lines. And but yeah, we've got this big bill from Oklahoma that we're going to get into as deep as we can. It was so long, I didn't feel like doing all the work, so I plagiarized on this episode.
Shame! You should be ashamed of yourself. Well, do you want me to play this voicemail?
I do. I can't wait to hear it.
You don't lie well, Larry.
Hi, my name's Alex. I'm calling from eastern Pennsylvania.
Oh, Alex, not Eric.
I listen to your show all the time, but this is my first call. I'm scared about something that happened to me 2 days ago. My family and I were deciding on dinner when our dogs went crazy barking. They usually bark at the mailman, but this time it was different. I looked at our doorbell camera and saw two people outside. One had a police badge. They had a weird car blocking our driveway. I panicked. Even though I moved to Pennsylvania to be near family and I'm not on that list anymore, seeing police made me really anxious. I thought being off the list meant I could finally relax, but here I was wondering if I should run again. We didn't answer the door. They even walked around back to see if we were home. Then I remembered something. Last week my son joked to his doctor that I beat him. We wrestle sometimes, like how we used to watch wrestling on TV. Now I realize why the police and someone else were here. To check on us. I'm calling to share my story and get some advice. I don't need a lawyer, but I'm worried about what happens next. Should this get worse? Do I need to pull all of my money and leave town? I love your show. You give a voice to people who feel left out and misunderstood. Thank you for listening and maybe helping me out. Oh, and I donate to your show, too. FYP, which I don't even know what FYP means.
Do you want to explain that real quick?
Explain what FYP means?
Yes. I like when you explain it.
Well, imagine that there's a knock at your door and you choose to answer it. And there's a person standing there with a clipboard and they say that they would like to have the names of the people who are living in that residence. And you look at them really strange and you say, you'd like to have what? And they say, we want the names of all the people who live here. And you say, are you crazy? And they say, we have a right to the information. We have the right to know who lives here. What would your response be to them? And if it was not a pleasant response, what would it be? That's what FYP means.
Might they need to use FYP in their response?
That's what I think that anybody with half a brain would say under that scenario. And so it arises from this imagined right to know who lives someplace. That's how the registry is based, that there's a so-called right to know. There is no right to know. And anyone who received a knock at their door demanding a list of the residents in the house, and they asserted a right to know, the average person would not be very polite to them, and they would not recognize such a right.
Just out of curiosity, isn't that what the census people do? They don't demand to know. They don't say they have a right to know. But isn't that what they're doing?
That is exactly what they're doing. They're doing it under statute. It's demanded every 10 years that a census be taken. And if you happen to be one of those selected for the long form, you're going to get a lot more inquisition into your life. If it's the short form, they're basically taking mostly a head count and maybe some demographic data. But if it's the long form, they're going to ask you a lot more.
I see. All right. All right. Well, then let's tackle this individual's voicemail. And I guess maybe we should start by if you the first question would be, if the person was released from the registry, and they didn't tell us which state they came from, but they were released from the registry, assuming that they did all the proper procedures and whatnot, they believe that they're off the registry and they move, should they believe that they're done?
Well, it almost sounds like that was either a voice disguise or that's somebody from the South. Wouldn't you agree with that?
I believe so, yeah.
Okay, so someone decided to leave the South. Well, we can narrow it down because a lot of southern states, there's no pathway off. So if they were in Mississippi, Louisiana, Florida, they probably wouldn't have gotten off there. So they're North Carolina, Georgia, one of those states that they got off the registry. But if you get off the registry and you're not being handed off by virtue of being an existing registrant and you move, you could live in the state for quite some period of time, maybe the rest of your life. But that's not really the question you're asking. You're asking, are you done? Well, the answer is, legally, you're not, because each state decides how to define who's covered under their registration. But it's rational for you to think that you are. And I give the example so often when I have conversations that I think people can relate to. When you get a divorce, you file a petition for a dissolution of marriage or something similar, depending how it's styled in the various states. And your marriage is dissolved and you're granted some form of shared custody, or maybe the single parent gets custody or whatever, but you have a child custody plan and a marital assets division plan. All those things are adopted in the court that you filed for your divorce in. It would be very irrational to think that when you move to a new state, so if the person got divorced in Alabama, they moved to Pennsylvania, they wouldn't have to get a divorce all over again. That order would be recognized under the full faith and credit clause as being a valid order. Now, if the order had ongoing components to it, meaning that if the child was a minor, there were minor children, you would have to domesticate that order in the new state possibly, but that order is very much valid. Logically, you would think the same thing. When you file your removal petition, I'm assuming he filed a petition. I don't know of any southern states where they just time off that come to mind. If he was granted a court order that says, by the order of this court, your obligations have been terminated to register as a sex offender, I can't imagine why you would think you have to continue to register, even if you're in a new state, no more than you would expect you would have to register, get a new divorce. So therefore, it would be very unlikely that if you were ever discovered that you would be prosecuted for that because you had been dutifully terminated and you in good faith believed that you had no obligation. They would likely notify you of a duty to register if they believed that you had a duty regardless of what had happened in the previous state. But they're not going to try to put you in prison for the rest of your life because you wouldn't have had any expectation that you had to continue to register after you'd been terminated. So that would be my thoughts, that I don't advise anybody to take any particular course of action. But I can tell you that in all the history of NARSO and all the history that I've been in the legal business, since the registry has been running, I have not found a single instance of a person who's been dutifully terminated from registration by a process who has ever been prosecuted if they were discovered in a new state. In fact, we have just the opposite. We have done episodes where they have been apprised of a duty to register. We've had this very situation where they tell them, well, we know you're here now. You got to register. So speaking on my own behalf, if I had gotten dutifully removed from registration, I cannot fathom why I would present myself to a brand new state for registration. I would wait and see if they found me. That's what I would do.
And to maybe put it in your court, so what do you think that someone would do? So like what would you do that would draw attention that they would come visit you? Not that you went and visited their office, but like, do you think that getting into a little fender bender might draw enough attention for them to be like to actually run enough of a background check for them to report to the local registry people that you are a known quantity, but you're not registered here and you should be? Do you think that is enough of a trigger?
I think it would be very department specific for the level of work they have and the level of boredom that exists. But as I've been talking to officers over the decades, in the Capitol, I spend a lot of time talking to officers because we have downtime waiting for legislation to be called. They tell me that they want a couple of things from that NCIC when they run it. They want to know if you're wanted, if there's an active warrant out for you. That's one thing they want to know. They want to know if you're under active supervision so they can notify your probation officer if there's anything peculiar about what you're doing. And they want to know if you have a concealed carry permit because they want to know if your vehicle is full of guns. Those are the things that they are not telling me that they're running criminal histories. Does that mean that they're lying to me? Possibly, but I've gotten that consistent answer. What we're doing is looking for wants, I should say.
I'm sorry, what word is this?
Want.
How do you spell want? Is that want?
No, it's not want. Want is WANT. Want would be WAUWANT.
Okay, all right, Mr. Transcriptionist, there you go. There's your spelling for it.
So that's what they tell me that they're doing. But say you got pulled over in a place where they don't have a lot of activity going on, and the officer is bored and he doesn't like you because something that you've said or the way you're speaking to the officer, he or she may decide to dig a little bit deeper. But like I say, that's what they tell me. I would guess in our vast audience of tens of thousands that people get pulled over, and probably you get pulled over, those of you who live in smaller communities, by officers you might know. Ask them what they're doing. The way I learn things is by asking questions. Ask them. Say, when you're running, an officer, what are you looking for? They'll tell you.
I guess one of the questions that I'm asking in that, though, is that is there on their display on their computer, is there like a bing, 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 bing going off saying sex offender?
If you're actively registered, I understand there is. That's one of the things that an active registrant carries in them. There's like 17, 18, 19 different fields of the NCIC that they look for. There's some person fields, and then there's like for stolen property, and I can't name all of them, but there's more than a dozen things. And those things are popping up to them. So if you're actively registered, it will tell them that. But they're not going to mention it to you if you're actively registered. But this person said he was done.
Yeah.
Yeah. So he would.
And again, we're taking this individual at their word. I don't want to, try to put words in the mouth because we only have so many details to cover in this little segment anyway.
Yeah, well, he says he was done.
Yep.
And so that's what I suspect happened was that uh, based on the phone call, this was probably an investigation by Child Protective Services because there's an obligation to report abuse and neglect. If the physician was told something that didn't sound quite right, the physician would have filed a report, and then Child Protective Services, which we call that's under our Children, Youth, and Families Department, CYFD, they're obligated to do an investigation. So they would have been coming out possibly to do an investigation. But what is possible is that I'm guessing that child is in school. I mean, would that be too far-fetched to guess?
I mean, why else would Child Protective Services be? I mean, if the kid were 18, they wouldn't be engaged. I mean, maybe if the kid's still in high school, then maybe, but I'm thinking the kid's not 18.
Yeah, well, if the kid is under 18, Child Protective Services, everybody that's enrolled in schools, to my knowledge, they have to have some guardian or parent identified to enroll them. So with information the school has, they could have run the parental background. And it could be a dual visit. They're coming out to figure out if that person has a registration obligation as well as to do their obligatory investigation. But do we have any idea how old the child is? Was that anywhere that I missed?
I didn't hear it anywhere in there, just that it was the annual exam. So no, we don't really have anything from there. Can we center this for a minute around what the home visit situation would be about with this, if that's what it is?
Well, if
I
it's
mean, what are they trying to do? Are they going to come in with like 12 officers and the whole tactical gear and shields and whatnot and go ransack the place?
not for an investigation by Child Protective Services, uh, more often than not, and this is not my practice area of law, it's only peripheral for us, but more
You know all
often,
things, though.
more often than not, it's not even a law enforcement investigation. If it is a law enforcement investigation, it's only because there was something serious alleged, and they're ready to actually start the possibility of bringing charges against the person. Wrestling around doesn't sound like anything that would merit prosecution unless we're talking about a 300-pound guy wrestling around with a 60-pound 9-year-old, which you could easily hurt the person. But if we're talking about a 16, 17, 18-year-old, and we're talking about a average size adult, I don't think that anything other than they just have a duty. They can't blow it off. When something
Yeah.
goes to protective services, they cannot just close the file and say just is too stupid, because if something happened to that minor, then that report would come back to haunt them. So they're going to come out and without any guns, maybe an officer as backup. If they determine that a parent has some sort of criminality, they might have an officer as backup, but it's going to be done by child protective service workers. They're going to try to find out what the parent's version of the events are. Then they're going to look at the evidence they have and try to figure out if there's anything there. Depending on the age of that child, uh, this likely isn't going to go anywhere. As kids get older, they're more difficult to place. The biggest threat that the state can hold over you is if you don't cooperate with our investigation, we'll temporarily take your kid. Well, if you're talking about a 5-year-old, it's fairly easy. You'll find placement for any child that's a newborn all the way up to beginning grade school. But as they get older and older, it's more difficult to find parents. And if it's a teenager, it's increasingly difficult. So
Kind of like puppies at the pound. Adult dogs never get adopted.
yes, so when you're threatening to pull a minor, if you're threatening to pull a teenager, you're going to have difficult time placing the teenager. And also the court standards, they look at a teenager is more able to protect themselves and to be savvy and alert. So what would be egregious enough to pull a teenager would be a little higher threshold to meet than if what would be egregious enough to pull a 5-year-old. A 5-year-old can't prepare their own food. There's just things they can't do. If you're talking about a 16-year-old, I mean, we were babysitting and making money and going out and doing things for our own back in the day when I was 14, 15, 16. I mean, it was expected that kids like that participate in doing things for the good of the family.
I don't think that's the case now, Larry. I think 16 and 17-year-olds today can barely like get out of bed and brush their teeth on their own without their mom wiping their ass.
Is that right?
I have seen things. Then do you imagine that this could have then triggered, I think you already said the truth to this, that this could have triggered the dual side of it, that there is a CPS connection of the Child Protective Services, whatever it's called in your state, but then also of like, oh, this person is supposed to be registered here and they're not?
It would be possible. It would depend on the person's last name. See, if you can run that call and figure out what the person's last name is, if their name is John Smith, you're just not going to have enough information to run a background check. You're going to need some information additional to that. I've not registered a kid for school. Do they take your date of birth as a parent? Because you need at least a date of birth to run somebody, unless their name is really, really uncommon. You're going to need a date of birth. So if this person, it could have triggered if they had enough information to run their background. If they ran the background as a part of the Child Protective Service investigation, they said, oh, this person has a conviction for that type of offense. It could be a dual investigation now. It very well could be. But my opinion would be that if they think that person has to register, all they're going to do is tell them, you need to get registered. We ran your background. We think our law covers you. And if I were that person, I would say, well, I don't think it does. I got this order here from whatever state is. I'm guessing he's from Georgia or North Carolina. I got this order. No, not order. I got this order here from the Superior Court in Wake County, North Carolina, and it says I don't have to register no more as a sex offender.
It sounds like you're saying odor, Larry.
So
you got this smelly thing from the court in North Carolina, odor.
No, it's order.
No, but on that then, so the person say that they live somewhere in Pennsylvania, and aren't there possible conditions that the person could be in Pennsylvania and not have to register if they had been deregistered on their way out the door of their state? I hope I worded that right.
I think what you're asking is, does the person have a credible claim not to register due to all the litigation in Pennsylvania? And I would say yes, because there's been a plethora of litigation in Pennsylvania engineered by largely...
They call them like Megan's 1 and 2 or SORNA 1 and 2. I can't remember what they're called. We've covered them here, and I just can't remember what they're called.
Yes, so depending on, again, that we don't have enough details from that call, but depending on the age of the conviction, it might be that they're not covered by registration. But see, your first line of defense is going to be to neutralize any possibility of arrest, as I got a copy of this court order here. And in my mind, I thought I was done. And they can't come, there's nothing they can come back with that. Nothing. I mean, what would you say in response to that?
I'm sorry, I'll have to get back to you. But when we talked about the one of the Georgia cases where you were there was a claim that I don't remember which county, they were harassing the people on the registry, going and visiting them at weird hours, knocking on the door and checking them. And I think that they only these individuals even were only annual registrants, but they're coming by either monthly or quarterly. And so you're asking for evidence, documentation of what time did they come by, and no one has a lick of a piece of paper that says Officer so-and-so or cop visited on 12/19 at 2 a.m. There was nothing that could be gathered to support the claim.
You're going to set me off on a path that I'm not going to be able to recover from, because that is one of the most frustrating experiences of my life. People tell me the registry is the most horrible thing that's ever happened to them, and that every right that can be imagined is being violated. And then I ask them for proof of these things, because you're talking about in Cobb County, Georgia, the sheriffs were telling them that they had to do things they didn't have to do. That wasn't in statute. They were inventing things. And I asked them, okay, well, what are they telling you? Who's telling you? When did they tell you that? What did they tell you in the way of the consequences would be if you didn't do these things? Like you had to report things that just those items were not required.
You had to report your job schedule or something.
Yes, there was all kinds of additional requirements. And I asked them, well, what do you have? Well, they're coming out visiting me once a month. And I said, well, are you keeping track of the visits? How do you know it's once a month? Well, I know it's pretty regular. Well, but did you track the date? I said, well, did they leave anything when you weren't there? Well, yeah, they left this flyer. Well, what'd you do? I throwed it away.
Throwed?
No, those throwed. And I said, well, why would you? If this is the most horrible thing that's happening to you in your life, and every constitutional thing that can imagine is being violated, why are you throwing all the documentation in the wastebasket? And nobody will tell me.
And so then by extension, I'm bringing that up as an example though, but then by extension, you expect an individual that has been released, they have an ALDA, I'm sorry, what was that word?
ALDA.
ALDA from that, where they were registered, they have an ALDA from the judge saying they are no longer required to register. And you want them to carry that around laminated in their wallet or something?
I would strongly urge anybody who has been removed by either a petition process or simply timing out in those states where you just time out. I would encourage you to keep that document and make copies of that document and be ready to present that document if the need ever arises. Because this is one of those situations where the first thing he'd want to do when they do come back again, I'm assuming he's going to call us next week or so and say they came back and we're going to find out the rest of the story. But he would need to be able to hand that to the officer and say, well, wait a minute. Now, before we go too far into this, I want you to show you that I've got an order from Superior Court of Wake County, North Carolina. And they're going to be shocked. Not a soul has ever done that. And they're going to have to run it up. They're going to have to run that up to their command to figure out what to do with it. And even without all that, they're still not going to arrest him. They're going to tell him, we think you have to register and we're giving you 10 days or 5 days or whatever the period of time is. But when you have that order, they're going to have to go run that past command. And command is not going to know either. And command's going to say, look, we have to run it past the county attorney or whatever, through legal department. And they're going to have to investigate all that, and they're going to get back to you. So that's what I would tell every person. Keep a copy of your order or your termination letter handy. Make multiple copies. Have one in your glove compartment. Have one in your house. Have one in your office. Make sure that that's available to you, because you may be in a situation where you have to explain why you didn't register. And you need to be able to say, well, I have this ALDA here.
And back to the, I can't do anything other than call it home invasion. Then back to the home invasion of them furiously knocking at the door. What is your posture in dealing with them? Do you open the door politely and kindly? He said something about the dog, so he's going to have to deal with that first, but then open the door and go, hi, may I help you? Do you come out the door with guns blazing? And I don't mean literal guns, but I mean, do you come out with an obstinate kind of disrespectful attitude?
Absolutely not. These officers and the child protective workers, they're all doing their jobs. And you treat them with the utmost of respect, even if they're marginally respectful to you. You treat them with the utmost respect and cooperativeness. But remember, though, you do not ever have to incriminate yourself. You do not have to ever admit anything. You don't forfeit that right, but treat them cordially and professionally. And you don't have to let them search your house. But I would much prefer to have the conversation in my living room than at my front door with every dog barking and with people wondering what's going on. And particularly if they were in marked uniforms, marked cars and stuff like that, I would much prefer that they be inside. So, you might as well invite them in, be cordial, try to get to the bottom of it. And that cordiality is going to translate to, they're going to go back and say, yeah, we got to run this past legal. Yeah, we never encountered anything like this before.
Carl asks, would you keep a PDF of the ALDA on your phone? I have a problem with that one.
I don't think there'd be a bad idea to have a copy of it. I think that digital documents are being more and more accepted. I think officers are now accepting a digital insurance card rather than you having to have the paper card. So I don't think there's anything wrong with that.
The problem is that you're then handing your device to law enforcement, and I got to think that they can then start swiping where you didn't intend them to go investigate your phone.
I have never been comfortable handing my device to a stranger, but having it on your device is a good thing, because at least you can say, look, I'll text this thing to you.
Yeah. So, I got you on that. we should probably move on. We've been on this for a little while. Is there any closing thoughts that you could think of just randomly?
No closing thoughts, but I hope Alex calls us back and tells us what's happened in a little bit more detail, because this is fun.
This is fun. Funny or just fun?
It's just fun because it will prove my point in terms of what I believe would happen for a person who's been dutifully removed from registration. If he's been dutifully removed, he's going to tell us what they said if it deals with registration.
Very well.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Well, next, we carried this over from a bill. We carried over a bill from Oklahoma because you had been lazy and just doing nothing. Because I don't know, you were like doing your legislative stuff 2 weeks ago, and you weren't prepared to discuss it. So, are you ready now?
Well, thanks to Sandy and Marcel, I'm as ready as I'll ever be. Sandy and I, we discussed this and proposed in detail, and she wrote a blog, and I helped her with the blog, and I figured that since I helped her with that, I can borrow from it. So this, if you've seen some of these statements before, it's because they have been out there already.
I see. And this is House Bill 3992. So tell us, what is the purpose of 3992?
Oh, it's to protect children from the horrors of sexual abuse. The legislation purports to offer such protection, but it's often these types of things are proposed in response to rare and horrific situations, and that's exactly what happened in Oklahoma. That's what happened.
Everything is about protecting the children. I mean, you could say, I don't know, you could say we have to put up this water tower to protect the children from, you could come up with the most ridiculous thing and you say, but it's to protect the children. And then you're a piece of crap for not supporting something that would protect the children.
That is correct.
All right. Well, in all of that, then, do you think that this can be killed?
So I don't think I have to answer it now. Is that a good enough answer?
I think that might be enough answer. But could you possibly elucidate our fine audience on what else you might think about it?
I'm thinking it's unlikely. But I'd actually prefer to quote an Oklahoma advocate, because I have reached out to an advocate over there who posted something on the affiliate listserv, and I'm going to quote him. That way you can be mad at him.
Okay.
He says, I do not see any way to stop this bill, considering the media attention to the overall situation and by the fact that the Republicans control the Oklahoma legislature. Remember, that's Mark, not me, saying that. The only time that we have affected any legislation is when the committee in the committee stage. Once it's on the floor, they're going to pass whatever they have against us. House Bill 3992 has passed the House of Representatives Criminal Judiciary Committee by a vote of 6-0, and I verified that by pulling the Judiciary Report. The committee report does not show any changes to the language as it was originally proposed, and therefore the next step is to go to the House floor as is. We must assume it will pass the House floor. The legislators could change some language there, good or bad. Then it'll go to the Senate, where it'll be assigned to a Senate committee, which will likely be Judiciary as well. If we want to make any changes to this bill, the Senate committee is the only time we can do it. It's my personal opinion that there's no way to stop it in the Senate committee, and the most we could do is get some language changed. Now that's end of the quote from the Oklahoma Advocate. I agree with him, and that's why I called him on the old-fashioned phone, and we had about an hour and 37-minute conversation last night.
You said about, and then gave me a very precise amount of time.
Well, we had two calls, but I remember the last one was the phone for an hour and 37 minutes, and then we had another brief conversation. So, well, we talked quite a while.
And tell me more of the driving forces behind the legislation.
Well, the impetus for the bill was a tragedy for several families. This guy named Jesse McFadden, who had served 16 years for a sexual offense and was due in court on the day of the tragedy for another one, shot his wife, her 3 children, and 2 teenage girls who had spent the night with McFadden's stepdaughters before killing himself. So you kind of had carnage that's behind this. The families of the visiting girls proposed a set of demands, and they contacted an Oklahoma legislator about sponsoring legislation based on those demands, and that's how we got to where we are.
Wow. Okay, and like that's even just hard to like listen to, and that would then be so that is a significant tragedy that is driving the bus.
Yes,
You have a one-off event that's going to then drive legislation that impacts everybody. I always love those, Larry.
indeed. Yes, the major elements are represented in under this bill. Persons found guilty for the first offense for 6 different sexual crimes against minors under 18 would be required to serve 100% of their sentence by the court with no good time credits. Persons found guilty of the same crimes against minors who were parents or guardians of those minors as perpetrators of these offenses often are and would be given sentences of life without parole. Now, remember, this is a state that believes in fiscal responsibility and looking at every dollar that they spend very critically. But I mean, who's talking about that? A second conviction could render a person eligible for the death penalty, even although there's a separate bill pending that has no chance of passing that's going to declare a moratorium on all executions, and it's in the House of Representatives.
I read that these penalties apply in most circumstances to all 6 crimes, including simple possession of CP.
That appears to be the case, but I'm going to tread lightly because it's such a long bill, and I really still was not able to fully wrap my brain around it. But the bill also mandates a life sentence of life for life without parole for first-degree rape of an adult, first offense, and someone accused of raping a child under 14 a second time could face the death penalty.
I'm sorry, the death penalty? What is the fixation with the death penalty? There are a number of states that already have death penalty legislation pending this year. And in fact, there was one in your neck of the woods.
We did indeed have such a bill. Fortunately, such bills have no chance of passing here due to staunch opposition from virtually all Democratic legislators, and the Democratic Party has strong majorities here, so that doesn't have any chance of passing here.
What would be the results of the bill then? Most people are convicted under plea deals with no trial, and still our court system is clogged. But then with this bill, isn't it more likely that accused persons will insist on a jury trial? That a guilty plea will result in the same punishment as a guilty verdict at trial? Or do you think prosecutors are unlikely to offer a much reduced charge since the purpose of the legislation is either to kill or incarcerate forever the people who committed these kinds of crimes?
Well, I mean, you're zeroing in on what the problem is. This is to get tough on offenders. So prosecutors, since they're elected in most jurisdictions, including Oklahoma, they're not going to come in after this passes and start offering sweetheart deals. They couldn't because they would be out of office on the next election cycle. So they're going to have to push forward under the spirit and faith of this bill to give the people what the people want. The people right now need to be standing up. If this is not what they want, they need to be contacting their representatives, as this is on the House floor. It's on the House calendar waiting to go to the floor for debate. They need to be saying, don't vote for this. But there's not likely to be any leniency because they would be vilified. Those prosecutors, they'd say, well, now, wait a minute. Now, you done cut a sweetheart deal with this man here, and he's supposed to be getting life without parole, and you done bypassed the will of the people, and you done, I mean, what are you doing? I mean, so, yes, you would expect that there'd be no deals offered, and more people would go to trial. If you cannot induce a plea by rewarding the person for the plea, you got nothing to lose. If you're going to have to serve 100% of your sentence and you can't plead it down to a lesser charge, why not go to trial?
Tell me about the mentality here being that this would be a very fiscally conservative state. Why would they enact something that's going to cost them $50,000 a year times the number of convictions for forever.
Well, you're actually finally beginning to see through their hypocrisy, which I try to point that out all the time. Uh, it's like, folks, hold your team accountable. When they run on platforms of being fiscally responsible and trying to keep government small, make sure you remind them of that when they're debating something like this. Make sure you tell them this is not consistent with your views, that you don't believe that locking up everybody is going to be the solution. But I guess we have to ask the people, how many prisons can Oklahoma afford to build? They will be needed to contain the plethora of men and maybe even some women who will see life inside prison. What will happen with taxes? Will Oklahoma's other services have to be reduced in order to pay for this ever-escalating Department of Corrections? And see, it's not just the Department of Corrections. That's the blunt of the result, because the end result will be much longer sentences. But you're also talking about the entire criminal justice apparatus. You'll have more need for court personnel, because if you don't do as many pleas, you need more judges. Well, you need prosecutors to cover the courtrooms. You need support staff to build the cases to ready for trial. You need defense attorneys, which we're going to get into an article about the shortage of defense attorneys in another state. So you will end up putting stress all across the system with something like this. But remember, this is conservatism here. So I'd hate to see what would happen if there were a bunch of liberals.
Isn't something like this just like most things that are so far complicated and nuanced that how would you communicate to the voting population of this trade-off of dealing with these kinds of convictions? Therefore, we're going to need all these extra places to put the people, along with the whole support system to prosecute, to put them somewhere. We need to increase taxes by, I don't know, whatever that number would be, $100 million a year or whatever. And we're going to have to tax you more. And then everyone, their answer would be, yes, please tax me more.
No, that would not be their answer. That would not be the answer at all. People have gotten so negative about government. They believe that everything is crooked, corrupt, and there's a lot of waste and fraud and abuse. And they've heard that coming from conservative circles for so long that if government would just run like a business, that we would have plenty of money. Even though our taxes are lower here than every country that we try to compare ourselves to, our taxes are lower. But they believe that if they would just cut out the waste, see what we need to do, that money that Biden's trying to get for Ukraine, we need to spend that here in America. That money for Israel, we need to spend that here.
Until they want to go spend it somewhere else.
But see, the funny thing is, those are not recurring revenues. No one believes we're going to be in these wars in perpetuity. Prisons live in perpetuity. If you put someone in for life, depending on the age of the person, you're talking about, decades to many decades. But people don't believe that the money is not there. They believe that there's just all this slush out there because they've heard for so long about how wasteful government is. And there is waste in government, as there's waste in private business. There's nothing that you couldn't go in and cut. No government, no company of any size, you could go in and find ways to reduce overhead. But there's not enough money in the Oklahoma budget to significantly increase what you're spending on corrections and prosecutions and defense without having some impact on other services or taxation.
And just that, what you just brought up is the waste in human resources is pretty much incalculable. The majority of those serving out full sentences or are in prison until their deaths will be based on just a first conviction. And what of the children? The reason behind all of this, are they actually safe now? Years of data from countless studies across the country show several things about sexual offenses against children. Approximately 96% of all sexual crimes committed by those with no prior convictions, just like the ones who will be filling out Oklahoma's penal institutions. Between 95 and 98% of those with CM charges are the relatives or other authority figures, peers of the victim, just like the ones that are already locked up. So it's not like you're preventing the future, because the vast majority of them are somebody that's known, that's not known to the family, but not to the criminal justice system.
Correct. Now, this is where Sandy really helped. I would never have thrown all that. You know how I think about recidivism, all this data and stuff. But
I've heard your comments.
This is an appropriate use of it. In this particular debate, this is a very appropriate use of this data. But I wouldn't have had this. But this is absolutely true. We can achieve the same result without putting people in prison for life. We can do what we need to do. This McFadden is an anomaly. Just like the person that shot up Vegas, what was it, 71 people or what it was a few years ago that shot up on the Strip? He's an anomaly.
The one from the window with the bump stock?
Yeah.
He injured 500 people.
But I'm talking about there was dozens of deaths. But that was an anomaly. That doesn't happen every day. It hasn't. This is going to be a one-time thing. There'll be decades go by before something like this happens again in Oklahoma. There's no need for all this legislation. But that's what they're doing. But anyway, I'm reading from Narsel's most recent post. Quote, Jesse McFadden was an anomaly. He murdered 6 victims before taking his own life. The victims of those families want justice. They deserve justice. However, justice does not involve using the horror he created to enact laws that will not prevent such tragedies from occurring in the future. It does not involve bankrupting Oklahoma's coffers forever warehouse more and more first-time offenders. Justice is designed to bring some degree of closure. Rather than helping with closure, House Bill 3992 would create a nightmare for individuals, families, Oklahoma's court and legal system, and the entire state for generations to come. End of quote.
I have a question for you, Mr. Policy Man. Are there any, I don't know what the right word would be. Could there be a trigger in here to see what the impact is after X years? So we'll say 5, we'll even say 10 years. After something like this is enacted, to force them to go look at, has there been any changes? And if not, kill it.
You know that track you just played?
Maybe I should play this one just to comment on it.
Run by the strangest collection of misfits, Looney Tunes since the advent of the Third Reich.
And that would be me in this case.
So
I would be the bunch of Looney Tunes.
It would be very difficult to do that. But you're not totally off your rocker. There are pieces of legislation that sunset. But this would not be one that would be in that category. Can you imagine the uproar that would happen if you passed something like this and had a 10-year review that was going to sunset without the proof of efficacy? Can you imagine what the victims advocates apparatus would do to anybody?
Yeah, they would lose their minds.
They would come in and say, now we're having to be victimized again. We thought we fixed this back in 2024. Here we are in 2034. And these gutless, spineless, weak-kneed politicians are ready to take away what we worked so hard to do. So that's not a very likely thing to do, although it does make some sense.
I'm trying to remember, is it Nancy Yates? I can't remember the woman's name, the one that offed all of her children in postpartum depression. Like, that is a incredibly traumatic one-off experience that I don't know how you build any sort of societal policies, legislation, anything to try and track that kind of event and prevent it, because it's just so far outside of the norm that there's like nothing that you could do about it. I just don't see how you could do anything about it.
Yeah, her name was Yates. I don't remember her first name, but yeah, that's the one that drowned the kids, right?
Yes, I was trying to be nice and like not describe that.
Yeah, so, but yes, it's very difficult though in this mass media age we're in, when you have so much publicity as McFadden generated, to tell victims, sorry, this was one off. Get used to being without your loved ones. It's very tough politically to do that.
Certainly. Well, all right then. So get ready, Oklahoma. There you go. You guys asked for it. Maybe not you guys, but they did.
Oh, I have one other funny thing. When I was talking to the Oklahoma advocate, he said that Democrat member of the House. Now remember, the Democrats are virtually extinct in Oklahoma, but
Right.
there are places like in Norman, where there's a university presence, you might have a Democrat slip into office. And he said that a Democrat was going to try to amend the worst parts out of the bill on the House floor. And so we've got a clip for that about what his chances would be to take all this bad stuff out of the House with House floor amendments. You want to play that again?
Which one am I playing?
The first one we played.
Oh, that? Okay, I hate that laugh.
That's about
that laugh.
The chance of a Democrat with a state that has virtually non-existent Democrats being able to, floor amendments are already tough to do. And trying to make dramatic changes with floor amendments when you're in the minority party, and not just a minority party, but an extreme minority party, would be almost impossible.
Isn't it supermajority in Oklahoma?
Supermajority. And so I was explaining to him, I said, well, the first thing, the way it's going to go down, if he offers floor amendments, if that representative from Norman offers floor amendments, I said, the first thing will happen is they'll actually pass out printed copies like they do in the old-fashioned days. You know, they'll go around handing each member a printed copy of the proposed amendment. And the majority leader, which will be a Republican, he will look at the sponsor's seat, and the sponsor will give him a signal. Basically, usually a thumbs up or thumb down. That's either friendly or unfriendly. And I cannot imagine that the sponsor of the bill would give the thumbs up to an amendment that would weaken the legislation coming from the minority side of the aisle. I just can't see that happening. So therefore, that's why that laugh track is appropriate. There would be very unlikely that a minority member could affect any meaningful amendment. Now, if a majority member were to make that proposal, and if he or she were to talk to the sponsor first, because you always look to the sponsor when something's being amended. The sponsor determines whether it's friendly or unfriendly. And if the sponsor has already had heads up and there's been discussion, oftentimes they'll say, yeah, we consider that a friendly amendment. But I just don't see that there's going to be any dramatic changes to weaken this legislation. It's not likely because it's just too hot potato over there.
Right. Very well. Well, you people, you put an article in here from The Chronicle, and it's Washington's public defender system is breaking down, communities reeling. And this is from the state of Washington. According to the article, when you're charged with a crime that could put you behind bars and you don't have enough money to pay an attorney to defend you, the government is supposed to provide you with one. But that isn't happening in some of these communities in Washington state, at least not right away. So isn't that like if you have the right to remain silent, your Miranda rights, like if you don't have enough, if you can't afford an attorney, one will be appointed to you? That's the thing that they say?
That is correct. And you do have that right.
So what's happening in Washington?
Not sure, but according to the article, Judge Paul Tanner told one defendant, quote, "We have a shortage of public defenders, so that's why we're in a jam." So basically, just sit tight and get used to it.
And the right to an attorney is rooted in the U.S. and Washington's constitutions? This sounds bad to me.
Indeed, it is bad. As the article points out, there are consequences. In some instances, people presumed innocent are languishing in jail without counsel. In others, prosecutions have been delayed or dismissed because defendants lack representation, potentially putting crime victims and others at risk. And still others, defendants are getting shortchanged because their attorneys are too busy. Now, folks, we just attacked a conservative state. Now we're going after a more liberal state because it doesn't matter whether you're liberal or conservative. If you're not doing what you're supposed to do, FYP doesn't cut you any slack.
The article stated, cash-strapped counties are watching their expenses soar with minimal support from the legislature. Some counties are actually suing the state over that reality, and experts say it's only a matter of time before an unrepresented defendant also sues, alleging their rights have been violated. Can you dig into that? Like, what grounds, what charge, what would you bring if you are not afforded this attorney and whatever? What's the scenario and what do they charge back with?
Well, I didn't see what the basis of what they think the lawsuit would be, but one would be, since you're presumed innocent, you certainly have the right to a speedy resolution. And you would say that the detention is not justified or warranted because there's no evidence been presented to merit your continued detention. Because the judges tell them, just sit tight, we're short staffed. And how long should you sit tight in custody?
Right.
So,
And
but
couldn't they just somewhat throw this back on the judge to put people out on bond, OR bonds, perhaps?
I think that'd be a risky proposition depending on the nature of the charges, and I don't know if the judges
Sure.
would have that kind of political will or even the authority to do that, to just simply start ORing people. But we're at the precipice of collapse, according to Franklin County Administrator Mike Gonzalez, and it's not affecting us; it's the entire whole state. Things grew so bad last year that Larry Jefferson, director of the Office of Public Defense, begged the Washington State Supreme Court for relief. He asked the court justices for a 90-day moratorium on attorney assignments for out-of-custody defendants in order to clear the backlog of clients who were already in jail. He asked the justice to immediately lower caseload limits for defenders, partly to keep the overburdened attorneys from quitting. And the justices surprisingly denied all of Jefferson's requests. Isn't that shocking to you?
Well, so God, like very early, you hammered home the point that the individual that controls the court calendar is the prosecutor. So they could just take accused of murder kind of charges and accused of shoplifting a candy bar and say, we're not going to prosecute, or, slap on the wrist, whatever that means. They could kind of handle this just in-house. Do I have that sort of right?
You do. I've said that, and I don't deviate from that. The prosecutors ultimately control the calendar. But picture this scenario. You already have a heightened sensitivity because the conservatives are already trying to convince people that crime is out of control since the pandemic. Remember, you've heard about how horrible these liberal-run cities are and how the crime is just off the charts, right?
Yep.
Okay. Well, picture a prosecutor saying, well, I'm not going to prosecute charges because those who I would be prosecuting are not going to have attorneys because there's a shortage of cash and there's a shortage of staff. So we're just going to prosecute only certain offenses. And too bad, so sad, not enough defenders around here. Can you imagine how long their career would be if they took that posture?
Sure. I have a novel idea, Larry. Why don't we get like those that are in school trained up to be like interns, and they could be the ones that represent you as your public defender? Does that sound like a good idea?
That was actually mentioned in this article. You must have read the article.
I may have, Larry.
So,
do you think that would be a fix?
I think it's a good possibility. I don't think you'd want to assign really serious cases to rookie attorneys, but because you've got,
I guess they get experience handling cases.
Yes, but like I say, you run the risk of ineffective assistance of counsel, and you have the risk of verdicts being overturned with inexperienced attorneys on significant cases. So I would not put those guppy attorneys on very significant cases.
Guppy.
So
advocates say communities should reduce pressure on public defenders and the entire system by scaling up alternatives to prosecution, especially for nonviolent and lower level crimes.
Well, I agree with that. The article eloquently points out that defender shortages and unrealistic caseloads are posing a threat to rights cemented in court decisions like 1963's Gideon versus Wainwright, where an unrepresented Florida man challenged his state conviction and he went all the way to the U.S. Supreme Court and he won. The underlying principles are simple. Anyone charged with a serious crime needs an attorney, and to be effective, that attorney needs a reasonable workload. But those principles crumble when public defenders are scarce. Defendants have no one to talk to or with about their case options, and to argue for their release as well, and so they can keep their jobs and their custody of their children. And they need to be able to interview witnesses, to participate in their defense, to help secure evidence like surveillance videos and so forth. All this kind of stuff is important. And if you sit languishing in jail with no attorney, it's hard to do all those things that are necessary for effective trial preparation.
What about a person's right to a speedy trial, which sounds vague to me? What does speedy even mean? Is there a definition of speedy?
There is, and it varies. According to this article, that's a good point, but the right to a speedy trial within 60 or 90 days of being arraigned in Washington, depending on whether the defendant's in custody or not. But that also gets twisted when the public attorneys are scarce, leaving the people in custody. And in Benton County, I think that's what that article said, they're faced with choices. They're told that they can either move closer to trial without representation, or they can pause the speedy trial clock, meaning sign a waiver while they're waiting for a defender. Now that's a horrible option, because if you waive speedy trial, guess what? They're never going to bring you for trial, bring you to trial, and so that's not fair.
Do they just let you languish then in the county jail?
That's what could happen if you waived your right to speedy trial. So, and that's not fair, according to Sherry Ortel, a resource attorney for the nonprofit Washington Defender Association.
The article states that Washington's challenges are distinctly thorny, partly because its system is decentralized, with each county court administered locally. Most other states pay for public defense services, whereas Washington covered 3% of the cost through grants and special programs in 2022, according to the data collected by the Washington State Association of Counties. Sounds as though a centralized state public defender system might be at least a better approach, not necessarily the best, but a better approach.
Well, I agree, but most of the counties that responded to a survey last December reported vacancy rates of anywhere from 10% to 67%. Now, you have to admit a 67% vacancy rate is funny.
No, I'm not saying, Larry, nothing you ever tell me is funny.
If there's 2/3 of the staff positions vacant, that would all but shut almost most businesses or most operations down.
Yes.
And 34 reported recruiting and retention issues, up from 31 in 2022. But larger counties simply employ staff defenders, and smaller counties rely on independent contractors in Washington. And it seems like the smaller counties are having the most difficult problem because there are not enough attorneys available to take those contracts. And more spending on public defense and lower caseloads may not even be adequate to solve this crisis, given the severity and the magnitude of the cost involved, according to some of the advocates working on it.
Larry, I have a solution to this that would be easy as pie. Have Bill and Jeff pay for it. It's their state. They could afford it.
Who's Bill and Jeff?
Bill Gates and Jeff Bezos.
Oh, okay. Duh.
Between the two of them, they've got like $300 billion.
That's a great idea.
See? Piece of cake. See, I solved it just right here. World hunger is next.
Let's talk to Bill and Jeff about that.
We'll do that. We'll get them on the horn and have them as guests next week. Is there anything else that we should cover before we get out of here? We're pretty much over time.
I think we've done a great job. I was glad to be with you.
Good grief, Larry. You dropped like 75 articles in here. How did you think we would have time for this?
You never know.
Oh, my God. Anywho, go over to registrymatters.co and you can find all of the episodes, and that'll link you over to FYP Education, where you can find the show notes, etc. And as Alex did earlier, he left voicemail at 747-227-4477. 747-227-4477. Someone asked me, like, you said that too fast. Like, just rewind it. You could play it again. Or, as I said before, go to registrymatters.co. You can find it there. Also, registrymatterscast@gmail.com if you want to send us an email message. And, of course, if you would like to support us, which is much appreciated from all of those that support us, thank you so very much. But that is over at patreon.com/registrymatters. I got nothing else, sir. And if you have anything else, then let me know what you want to say. And there we go.
We'll see you in a week.
Take care, my friend.
Good night.
You've been listening to FYP.